Welcome to another episode of Legal for Tech, the podcast. As I said many, many times, it's Rosie here, actually Rosalia, as I've been told off for not using my name correctly. So we're just a group of students and young professionals who are interested in anything that's technology and its regulation. So today we have another guest for all of you. It is the author of a very, very interesting and very useful book. It is called AI Compact, Compliance Management and Use Cases in Corporate Practice. And so welcome, Peter Hense, who is from Germany. I hope I didn't completely get the name wrong. And he co-authored the book with Tia Mustache, who is not joining us today, but I mean, she's always welcome, of course. So welcome, Peter. Nice to meet you.
Thank you. You pronounced my name more than correctly. And Thea is unfortunately still at home, so she's enjoying her holidays, and she would be a much more joyful conversation partner than I am. But I'll tell her about it, and maybe she will join you at another episode and another topic, maybe. But yeah, cool. And
That
it's
would
it's a
be a
pleasure
pleasure.
to get to know all of you. That's great.
Yes, and as you said, it's all of us because today I'm joined by my colleagues, Giacomo and Giacomo. Say hi, guys.
Hello. Hello, everyone.
Hello, guys. It's a pleasure to hear you. So I am here to actually bring some breaking news with Peter. So tell us the news. What's happening in the European Court of Justice?
Yeah, I mean it's an event that it's not every day that you have a case in general court, which means it's not referral questions, like stupid referral questions, and then referring back to the national courts for the final decision. Now we brought a case for an individual against the European Commission for illegal data transfers to third countries. In that case, it was through the login with Facebook situation, with which you could register for European Commission events. And we said, like, this is probably not the best way to do it, especially since there were no safeguards for third country transfers. And we claimed for this individual, we claimed for for the commission to cease and desist with that practice through an action of annulment, which the court seemingly declared as like inadmissible, but they took all the arguments that we brought forward and merged them and granted them on the third or fourth point, which is damages. So they granted a substantial amount of damages, 400 euros, basically for the transfer of an IP address to the US, which is what I figured from the press release, because we haven't seen the decision in full yet. And especially given the situation that we started with that as a kind of, well, we should do something about the situation. All the national courts are struggling with interpreting the Court of Justice decisions. We need something more concrete. So from the first idea until the final decision today, it will be appealed both by the commission or by our client, no doubt about that. But it is definitely something interesting, especially like a year and 2 months ago. We were at the oral hearing, and I was extremely surprised by the professionality of the judges and the questions that they asked us. It was for an hour and 30 minutes of like an intense interrogation of mostly the commission, sometimes us. And yeah, well, it was like sometimes we felt like we were losing it during the process, and sometimes we felt like it was kind of too much. It was like a physically exhausting, this whole situation, the hearing. But in the end, it seems that it turned out like pretty well. We did not expect it
So
to turn out like
that
that.
you would say that the preferred outcome was to receive compensation, or would you have rather
It was
had a more
the preferred outcome was to have some clarity. So it could have been by rejecting the claim and saying, well, there is no claim at all. Well, fine, then we have the clarity for other clients that are using, for instance, like or haven't been very careful about their third country transfers. And this time it was like login with Facebook or Meta. It's just a placeholder for any third country transfer. And if that's the US, a country with a relatively close to being a democratic system with judicial oversight, what about other countries? What about, let's stay in a more civilized world. What about Mexico? What about Colombia? What about India? And what about China? What about Russia? So, so onward transfers are a huge issue in this field. And from what I see now is that the General Court, they extended the chamber. I still don't know whether it was the Grand Chamber or fifth plus 3 other judges. The court took it very seriously, and yeah, I'm really looking forward to the details of the decision, especially the explanation of why they granted damages for that part.
Do you see data transfer as being a form of foreign policy for the European Union?
Sometimes I reserve my right to shut up or on political and policy topics. I know people are fascinated about like policy making, but in the end, you know, the only thing that matters and that counts is being in court, getting a decision, changing behavior. Policy making is maybe like doing something that looks good on paper and that in the end, like nobody cares about. Let's like look at all the AI policymaking, AI ethics committees, AI blah, blah, blah. The law flows in a sea of ethics bullshit that we read everywhere. In the end, it's either contractual liability or tort law that will bring the perpetrators, bad people, to their knees and make them comply with like what is just and what is right. So again, I think whatever the commission or whatever the lawmakers thought when they introduced Article 7 and Article 8 and 47 of the Charter, I have no idea. Maybe they only had a vague idea of Europe being the maybe guiding the way for the world. But it cannot have been more than just a fuzzy idea, because at the time when we got the Charter, the world was a different place, right? I think
Yes.
so. I mean, it was kind of quiet. I remember it as like it was okay. We had war in Iraq, but like everything else, it's like, compared to today, it was kind of quiet. And that foresight is admirable. So, and they gave us principles to live by, same as God gave to Moses. So, and we can choose whether we will honor them or not. And of course, this is leading by example. And to say, well, if you're not a democratic country, if you don't have judicial oversight, if you don't grant our people some rights, some redress, fairness, and then we should not transfer, and our people should not transfer personal data to that country. I mean, it seems it's an easy answer to an easy question. And then there's reality. Reality is we are being dominated by tech companies. They are lobbying extremely heavily. I mean, you have been to Brussels, you are in Brussels at the moment. So basically, behind every stone, there's a lobbyist. And in every cafe, there's a bunch of lobbyists. And not few of them work for Meta, for instance. So what is there? What hope is left if we have a look at, changing the topic a bit, to, for instance, the AI office and the weird codes of practice that they are beginning to publish? That's just like that's not lawmaking, but that's the product of heavy lobbying. So who is gonna uphold the rule of law? It's gonna be, in the end, it's gonna be 5, 6, 7, 8 judges. That's it. And that's beautiful, I think. And I want to see more of that. That's why I chose to become a lawyer and not a policymaker.
Well, that's beautiful to hear, especially because, as I said, many of us are students in this group, and this will be a wonderful. It is for me, and I'm sure for my colleagues as well, will be a wonderful source of inspiration for continuing to strive in the study of law, which is harsh and very long. So, having that said.
It is, sorry, to follow up on that point. You never know where life takes you. Most of like the situation that I'm in right now, like, is the result of a couple of events and not of like decisions that I took personally. It's the result of things that gone wrong. I never wanted to be a lawyer. I wanted to stay at the university. I wanted to become a professor for Jus Commoda and Roman law. That's why I was in Rome. That's why I studied with some of the best professors there, and I have an unfinished PhD work there with the Appendix Concilii Lateranensis from it's the collection of decretals, papal decretals from the 12th century. So anyway, I never wanted to be a lawyer. I never wanted to be in tech. That was a hobby. And only 10 years into my job, I started working on tech law. Before that, I did real estate law. Again, that's what life makes of our plans. It has its own plan, its own mind. So whatever you do, like, look for stuff that you're interested in, that like energizes you, and not do tax law because you think tax law is going to pay a lot of money. It won't make you happy. I mean, tax law doesn't make anyone happy. Look at the tax lawyers, but I'm just saying, look for something that makes you happy, that brings you purpose in life, and that's it. Yeah.
Thank you. That's beautiful advice. And I think you have something that makes you happy that's shared with one of my colleagues here, Giacomo, who will ask you about something that makes him happy as well. Please, Giacomo.
Yeah, we have to say that we have seen it everywhere on LinkedIn. Many professionals taking selfie with your book, AI Compact. And I think it aims to be a comprehensive guide for navigating the act. But what inspired you to write it? And how do you hope it will support the professionals in tackling the act's challenges?
Oh my God. How many hours do we have? It's weird. As I said, like, life is what happens when you're busy making plans. So like I've been working on systems that we now call machine learning / AI systems for the last 15 years, but we never thought about the AI component that much because it was irrelevant. It was just a system, it had requirements, it had to work somehow. And we dealt with contractual law, we dealt with product liability, with data protection mainly. That's like what I've been doing since 2008. And in 2017, I started 2014 actually, I started to read more about the topic of automated decision making, which became a hot topic in the US, not in Europe. It was pre-Article 22, and even Article 22 is basically the same as, I think it was 15 under the directive. It's a shitty piece of legislation that had no value at all. Everyone agreed, until the CJEU said basically, well, what you wrote there is completely wrong, and we are going to adjust it to make it more meaningful. Very cool. So now we have the strongest ADM laws under GDPR in the world, and still, like, reality hasn't caught up on that. But in the end, like 2017, first Trump administration, Kate Crawford, big fan of her. Kate Crawford said, like, artificial intelligence is ripe for abuse. It's a fascist stream, and it can and will be abused. That was when Palantir and the likes started screening the US population for illegal immigrants. and deporting them or putting like hundreds of children in a cage and stuff like that. So, but there were like a lot of other things going on. So I started working with the IEEE on a standard that was supposed to deal with algorithm bias considerations. IEEE engineering organization, lots of older people there working there after their like initial career, they start working on standardization. I was super impressed. First meeting in person. I was there in 2019. Interesting part is that sometimes like it's an intercultural situation, that same as we have with AI now. When there were experts on the topic, women speaking up and others not listening to them, interrupting them because they were women, because they were from countries where women are not allowed to speak. Interesting project working together, creating a standard about biases. Well, I mean, it was really cool. Then like 3 years of not doing much during the pandemic. I have attended 2 ACM Fact conferences whenever they were closed, like in Barcelona, early 2020 was extremely influential for us. And then we saw the legislation, one in the US, partially by New York laws, I think it was 144, and then the European Union's first draft, the present, the gift from von der Leyen to France for making her Commission president the first time. And the French didn't know much about AI at the time. They didn't care much about it, but they thought it would be a cool topic and a nice piece of legislation like GDPR 2.0. And they took medical device regulation, rephrased it, because they were like people at the time were scared about pacemakers plus ML components like IoT everywhere and shittification of every piece of technology, existing technology. Your whatever your phone has ML components already. Like what is it? Like smart lights. The time when everything became smart. Smart meaning IoT, meaning ML component, meaning it had to become more safe because otherwise it would be a problem. One, because it's unsustainable, because if you have complex systems, they break like very early. So you can get rid of them. So the planned or unplanned obsolescence of stuff, the incompatibility with the Sustainable Development Goals of the United Nations and the European Union, all of that crap came together. So, and I had a look at the draft and I thought, well, God, that's boring. Can't we for once make an interesting law? But in the end, I said, okay. And I threw my hat in the ring with the publisher and said, okay, I'm going to write a book about it. It's going to be a very short one, and it's called Introduction to the AI Act. So the negotiations around the AI Act dragged along, and they were about to give it up in late 2022. People forget about that. And then ChatGPT came along, and everyone was suddenly became an AI expert. I'm still extremely confused. I mean, I have seen a couple of things, a couple of hypes, the Bitcoin hype, Web3. I mean, that was already like doomed from the beginning, but all those weird things. But the AI hype is happened at a different scale. I'm really bad at math. I don't like it. I don't like statistics.
You can ask ChatGPT. It works.
Yes, sometimes, even though ChatGPT doesn't know math, but
not that well.
it took me like about 3 or 4 months to get familiar with the system. Reading and reading and reading and reading. There's no shortcut to knowledge, even though ChatGPT suggests you can be smart by having the machine influencing your thoughts and outputs. That's not how life works unless you understand, unless yeah, you understand. You don't know much about the system. So we have a deep neural network. Okay, yeah, I forgot to mention, like for a couple of years between 2014 and 2019, I was also the second CEO of a company that developed neural networks. So just out of interest, but I dealt with legal questions, not with the technology, and the technology people were there. Of course, I could look up later. I looked up all the documents that we had, and I thought, well, Now I actually understand. And we hit the wall with our product. Our product was was meant to improve travel search results on travel websites. And we crawled the web. So web crawling, familiar with that, how it works, who does it, and all the lies about it, like we respect robots.txt and other stuff. So anyway, we hired the same crawling company. They usually sit in Eastern Europe. Hired the same crawling company as Meta does. So same crawler running in the same service as Meta or Google. You get the idea. There is some sort of knowledge transfer between those in those situations. Okay. Anyway, we built the systems, but it never became better than it was a knowledge graph based on a deep neural network combined with a knowledge graph. You, for instance, stored every information you have on the Eiffel Tower in Paris, and you could look it up. Vector search combined in a vector space, and you were able to look for whether is there any coffee that serves hot chocolate close to the Eiffel Tower? And this information was in a DNA-based string for the Eiffel Tower. That's how a knowledge graph works. But in the end, the error rate, if you release the product for end users, the error rate was extremely high, at least 20%. And we were unable, and it is impossible to reduce the error rate of deep neural networks. It's just not going to work out, even when you combine it with a knowledge graph, which should provide some more clarity. So in the end, we sold the product in 2019, 2020 somehow. And I was familiar with how the systems work and how they, where they perform and when they do not perform very well. And the thing is, nothing has changed. Nothing. Same technology, same underlying technology. Life is infinite. The situations that we are confronted with in our lives, in our daily lives, is infinite. It's the traveling salesman problem. It cannot be calculated. Whatever you do, it cannot be calculated. So whatever AI does or is supposed to do, it's not going to work because we don't have the right approach, the right technical approach. That far I understood. Anyway, long story short, 2021, before the release of ChatGPT, I had during the pandemic, a friend of mine, he was working in Oxford at the time, doing his PhD on robotics there, and he works for DeepMind now. And he said, okay, let's do a podcast, a webinar together. So we had a 6-hour webinar podcast together, 6 parts, talking about the transformers are here. Unfortunately, it's completely in German. Funny thing is, we basically foresaw the whole development. So 6 episodes, and we are currently in the whole development. We are at stage, at the midst of the 4th episode. Algorithm audit, I think it was called. So anyway, all of that factored into, I want to write a book about the AI Act and everything around it. So what happened to everything around it? We didn't have time. I couldn't write about all the beautiful things that happened between 2013 and 2024 that had nothing to do with the AI. So we left out mostly the bias part, discrimination part, only 15, 20 pages on discrimination, which should be much, much more. But we focused on what the lawmakers left for us to deal with, and that's not much. It's a bad piece of legislation. It's incoherent. It is contradictory at best. But with our experience from how the CJEU interprets GDPR, taking Article 1, taking the scope of the law, and then closing the gaps. That's what we did. We tried. And Tia, she did most of the work is from her. The intellectually challenging work was done by her. And that's putting it into practice. She served for 5 months, 4 months with a major German company, and there she was in charge of the let's say an early AI governance process. So, and parts of the book are already out of those thought processes if you what do you do if you develop a system? What do you do when you purchase a system, procure the system? What are your obligations as a provider, as a deployer? That's basically, and I added some thoughts that I always had on the topic, and voila, there's the book now. Sorry for this very long monologue.
No. I think all of our listeners were very interested in knowing more about the book. It's been everywhere on LinkedIn. I can vouch for that. And I believe the point that you made is that the AI Act is not complete. And you had to work with other material that helped you understand what probably was the point of the AI Act in the end and how it could be applied. So there is this very strong connection between the Act and its implementation, and there's a whole gap in between, probably because technology is evolving, as you said. We don't know what's in the future. And on that point, I have a question on the board. Write about the future of technology. So please, Giacomo, enlighten us.
Exactly. The other Giacomo. Do you think that the balance between the regulation and technological advancement is well struck? And also, do you think if there's still room of maneuver to influence the implementation of the AI Act through the finalization of the GPAI?
Was the last part of your question, was the GPI, you mean the general purpose AI?
Exactly.
And the guidelines from the commission?
Exactly.
Okay, well, those are shit. They don't mean anything. The same as the codes of practice, they have no legal relevance. I mean, what are we talking about? We had Schrems 1 and Schrems 2 declaring invalid the Commission's decision on third country transfers, and those had a binding effect under the law. We have no binding effect under the law for any such recommendations. So, and to be honest, I have been vaguely involved with the codes of practice recently, and they're all shit. Like, it's unbelievable. They are deviating from pre-existing laws, so I'm like really not a fan of them, and I want to see them go up in flames, and I'm trying to figure out a way to do that. But anyway, the act as such is like, if you have 100 people on a table and then you with very different backgrounds. We had a very smart high-level expert group on AI in 2018. People don't know that, like, one of the main authors of the Attention is All You Need paper was part of the group, by the way, Uskoreit, also son of a German computer science professor who fled the country. So a lot of history on that. But anyway, the HLAG AI had, and I did not appreciate it at the time, but they did a pretty decent job. And their findings contradict, like, their findings are part of the law. They were made like, we want to go with the trustworthy AI approach. And then the law deviates from trustworthiness at so many points, not every single article, but like on so many points, that I would say the Court of Justice will have a lot to do to make that right. Also, if you look at the definitions, I mean, we defined training data. Why are they doing that? Why do you need to define training data? It makes no sense. And the lawmakers, they played a lot of those, we say the lottery, like in Germany, there's a famous lottery, it's called 6 out of 49. Right? You have to get 6 right, plus, or 5 right, or whatever. That's 6. And we call it, like, if someone like draws a picture of a problem or finding a solution, and then but plays 6 out of 49, like just mention 6, but you have to know all that it's just a small part of it. That's basically the AI Act. Article 10 mentions so many things, but also leaves so many things not mentioned that are prerequisite to understand. So how do I know it? It's and people don't have to listen to me, but it's like there had been technical standards out there before, And of course, like practice, there are books on machine learning that are like 30 years old that are better written than Article 10, 15 and the likes. We've been talking about feedback loops for 30 years, not just on social media. The thing is, we have a huge gap between comprehensive standardization, not just the harmonized standards, not just the ESOs, but ISO, IEC, IEEE, and the Canadians, the Australians, other standardization bodies with specifications, guidelines, and standards, difference between all of them, that explain how difficult it is to implement that in practice. And what the AI Act does, and that's a big, like, that's a big change, and it's a great thing. By mentioning, not just mentioning standards, but by using terminology that is technical terminology and making it a legal obligation, they pushed best practices and made them, basically made them legally sound, and made them a legal requirement for us to deal with during the evaluation, impact assessment, and especially the conformity assessment for AI systems. How all of that works together, no one knows. We tried. It's our first batch. Thea took like a month to figure out what could that mean, and we went with what is going on with the medical device regulation, the in vitro regulation, or directive. I mix those two up always, but and I had a look at other more technical aspects of the law, and I'm convinced it will influence future lawmaking around the world, and it's gonna be very helpful for Europe by making best practices a legal obligation, but not just best practice, and then you can sell a shitty product. No, making it a legal obligation, plus the combination with the conformity assessment, meaning you cannot put a product on the market that is a shitty product. The effects of that we will see only in about 5, 6, 7 years, because they will all release their newest systems right before the application of the AI kicks in, and using the grandfather clause of like, we will protect pre-existing systems. But with the first update, we will see so many high-risk systems where companies will try to define themselves out of the high-risk situation. But society will have changed by then, and that's where it becomes very interesting. One, I'm not sure whether the commission is actually under the law, under the charter, allowed to change the law, or whether that's a violation of our fundamental rights, because you cannot foresee what the commission does, and the commission is not the lawmaker. They are part of the body of making the law, but they can't just unilaterally determine what it is. But since we're talking about this, do they have at least the power to determine what is a high-risk system? What could be high risk, just because it's more factual, not so much legal? Well, maybe yes, and maybe the Court of Justice will allow them to do that. So we might see new products under Article 5 and under Article 6, or whole industries, like with HR. They did it with HR. Unfortunately, HR is now completely effed under the Act. But there are other industries, social media, for instance. They lobbied their way out. And but I think the the idea of let's make all the prohibited systems sound like they are science fiction and Netflix TV series, maybe it has failed, because reality is always taking advantage of ours. And the reality of TikTok and X has come very close to Article 5 already. So, and Trump hasn't even been inaugurated yet. We still have 12 days to go.
Looking forward to that moment. Hopefully the same won't happen in Germany as well, in terms of political parties. So just wrapping up on this point, you talked about things that are missing from the AI Act. because it's not an all-comprehensive regulation, and the effects of it will be seen in the future. With the hindsight, if you have to give a critical evaluation of the product, so of your book, would you say that these pieces that are missing from the AI Act prevented you from publishing a completely comprehensive piece of work? Is there something missing from your book, or do you think it's good enough for now for the type of technology we have right now?
Oh, that's an interesting question. Thank you for asking. I actually have to think about that one for a moment. I would say nothing, like apart from work and family and private life, nothing prevented us from writing this book, because we already said it's a compact version. It's our approach, and we focus just on high-risk AI systems by mentioning all the other stuff only en passant. So we already focused on what we thought would be necessary. And I think we would have done it anyway, irrespective of whether the act or the lawmakers would have changed something in the wording here and there. The flaws of the AI Act, or let's say the novel approach of marrying product safety law with fundamental rights protection, that's definitely an interesting experiment. And you could write books about that part alone. The fact is, nobody, no one, not in academia, especially not academia, which is completely useless for the AI Act, to be honest, completely useless. They have no clue. Like most of the papers that we see, they are so unbelievably boring and not on point. But like, nobody knows how the act will turn out. Which part of the act will be the most relevant in the future? What is the part that you could rely on to protect the rights and freedoms of individuals? And it could well be just the stupid conformity assessment. It could be national torts law, which is not excluded to rely upon. But it could also be human oversight, Article 14. Because to solve Article 14 with its weird details, you could win the legal Nobel Prize for that, is because there is no solution. There is a technical standard. It's a standard or specifications, a TS 8200 ISO IEC on controllability of AI systems. Have a look at that standard. 150 pages on that, and no solutions, just requirements. You should do this and you should do that. Without it, your system, your high-risk AI system, which covers a lot of systems now and will cover more systems in the future, are not in conformity with the law. So I don't know who is going to be the AI Max Schrems. Nobody thought Chapter 5 GDPR would be the driver for innovation in this field. You could not have foreseen that. Everybody thought, well, privacy by design sounds so cool. That's going to be the driver for the innovation. Privacy enhancing technologies. No, privacy enhancing technologies took off because of Max Schrems litigation under Chapter 5 of GDPR. Because that was a practical issue at the time. So we don't know how it will turn out then. So I think we we did something that was necessary. We presented the first practical overview of what developers actually have to do when complying with the AI Act. Here, go on, read it, with a lot of footnotes, mostly non-German, not so much academic, some academic footnotes, but like mostly non-academic footnotes. And then we will see how this turns out. I cannot predict much for the future, but like I would say the interplay between the UCP directive, unfair competitive practices directive, and GDPR plus AI Act, that might knock all the bad competition out of the market. A combination of all of those. but that's just a rough guess.
Well, I will be asking you about your rough guess in due course, because I can assure you that you will be more than welcome to talk about any future developments on this podcast. So let me do one last plug for your book, which is, I shall repeat it for our listeners: AI Compact, Compliance Management and Use Cases in Corporate Practice. I think it's available even in other languages, if I'm correct. I think it's available in German. So our German listeners are more than welcome to read in their own language. And I want to ask you one last question. It's less difficult, I promise. The question is, do you have any suggestions? They could be books, podcasts, TV series that could help us all understand the topic that you discussed.
Well, I had a very great curated list of people to follow on X, but I do not recommend using X anymore, and also most of the people from that list disappeared. Though there's a researcher, AI researcher list
Disappeared
also
from X, not from the world. Let's
it
make this
disappeared
clear.
from X. The people did not disappear. But on Blue Sky there are also like sources. So but you have to familiarize yourself with the topic, and I'm sorry to say that. So if you are currently interested in the hype tech that AI is, you could buy a book from Sebastian Raschka. He is, I think, of German origin. He is a machine learning engineer, and he wrote a book on how to build LLMs. So basically 300, 400 pages, very easily understandable, really cool book. Well, that's one thing. For the combination of European law and cybersecurity and technology and bias, follow Isabel Barbera from the Netherlands. Isabel is simply great. Like she's a genius, and follow her. She developed this AI, like it's a game to make you understand AI better. It's called Plot for AI. It was based on Intune for the software development. So Isabel, for the US, I suggest you follow Odia Kagan and Katharina Körner. Those two are mostly all over LinkedIn. And well, yeah, and also of course for if you're interested in the topic to be presented in a more digestible way, you could also listen to our podcast, the Reg and Decoding AI Regulation, that I'm doing together with Thea. And well, yeah, and in the end, it's basically, yeah, try working on the topic yourself. Try like stitching together stuff on the internet to create your first AI system. Why not? Get a little bit of experience there. Well, there's one more suggestion. You should also follow François Chollet, a French, I would say even professor. I think it was the inventor of the Keras framework, on any platform, and Jan de Koon, just for seeing where the discussion is going currently. So yeah, that's basically it. And again, it's nothing that you can understand or will understand by just attending a 2-day course somewhere. It's impossible. You need a lot of experience. You need to see it firsthand, and don't believe the hype. There's so much more behind it. It's not just LLMs. AI is not just LLMs.
There's a whole world to discover. Well, our listeners will definitely find all of your suggestion in the links to our show notes, and also in our LinkedIn posts that we will also invite everyone to repost and comment to tell you what you think. Also, thank you very much, Peter. And we also hope that you and Thea will join us soon to talk to us about all the future developments of your career, of your science, and well, everything that will happen with the hype of the day.
Yeah,
Um,
Thea will be a much better partner for any conversation that is related to professional choices. I mean, she's 25, so I'm 47. That's a
Setting the
huge gap.
bar high. Um, thank you very much indeed. It was a pleasure and an honor. So, what can I say? Vielen Dank. Thank you guys for joining me today on this podcast episode, and well, enjoy the rest of the week.
Bye,
Grazie a
Rosie.
voi.
See you next time.